Hi everyone, and welcome back to The Attorney Show on TV9. I'm Ananya, your host for today, and it's my absolute pleasure to be welcoming our guest today, Padmaja Chintha garu. Padmaja garu is a highly accomplished attorney recognized as a New York super lawyer, a distinction that is awarded to the top 5% of lawyers in the state. She is also a fellow of the Litigation Council of America. It's an honor given to 0.5% of litigators across the country. To top it all off, she's also made history being the first Asian American president of the Federal Bar Association Southern District of the New York State chapter. We are thrilled to have you here today, and we are excited to hear about your expertise, knowledge, and skill sets. And thank you so much for coming out today, and I extend a warm welcome to you.
Thank you so much, Ananya. Thank you for having me. I'm thrilled to be here.
Absolutely. So to just get straight into things, my first question for you is if you could talk a bit about your educational journey and kind of what brought you into this career in law.
Sure. So education-wise, most of my education happened in India. So I have an optometry degree from the All India Institute of Medical Sciences. I also have an MBA degree. I have a bachelor's in law from the Delhi University, and then I have a master's in law from the University of Pennsylvania Law School. In terms of what made me choose law, I think it's going back a while now. So back when I was a student in India, the government had introduced what was called as the Mandal Commission report, which provided for reservations for certain groups of people in jobs and college admissions, similar to the affirmative action here, and that led to a wave of protests by students, which was unheard of. Many even committed, some, not many, thankfully, some even committed self-immolation. So all of that unrest was unfolding in front of my eyes, and I thought, perhaps being naive, that if I had only the knowledge of law or the power of law, that I could somehow make a difference to the community. So that's what took me to law school.
Well, that's a very noble reason to get into this field, and I'm sure you've made an impact throughout your career, and I'm sure you're going to continue to make an impact, which we'll discuss further in this episode. You also are very highly accomplished in terms of your education, many degrees, which is phenomenal to hear. So my next question for you is, what made you choose to specialize in intellectual property and business litigation? Is there any specific experience that sparked your interest in this?
Sure. So in terms of, I guess, your question, there's two aspects, right? One is intellectual property or IP, and the other is litigation. So given my optometry background, it was a natural fit to go and do patent law, which requires a science background to be a patent lawyer in this country. So that was a natural fit. And when I was in law school, I had a couple of fabulous professors. One was a copyright professor, one was a patent professor, who made me just fall in love with that subject. So I decided I want to focus on IP. And then I also took a law school civil practice clinic where I got to work on real world litigations, helping real people, which I enjoyed very much. So I just feel, I love advocacy, and I find it incredibly rewarding to be able to stand up for my clients and fight for fair outcomes to them. So that's what gravitated me towards IP and towards litigation. And that interest was almost kind of like reinforced when I started working right out of law school. I went to a firm called Fish and Neve, which became Ropes and Gray, which was again big on both IP and litigation. We had in fact, gotten patents for some of the landmark inventions, like the Wright brothers aeroplane and Thomas Edison's light bulb. So, and we also secured one of the biggest damages awards at the time, which was close to $1 billion. At the time, that was the first time. So it was very enjoyable and stimulating work, and I decided that's what I enjoy doing most.
Awesome. You seem incredibly passionate about your work, and that's amazing to hear. So a little bit about your firm, Dunnington. Can you talk about what sets it apart from other firms and what you do to support your clients?
Sure. So Dunnington, Bartlow and Miller is actually has been around for more than 100 years now, and we're fortunate to enjoy a wonderful reputation as a premier boutique firm. We are a general practice firm with a particular specialization and focus in litigation, intellectual property, and corporate law. Our team also handles other areas such as real estate, wills and trusts, immigration, and a couple of other areas as well. In terms of what sets us apart, I really think it's the caliber of our expertise, the quality of our people, and our ability to provide solutions, practical solutions to business problems. Most of the partners here worked at the top big law firms in the country. That's where they trained and honed their legal skills. Some of them have authored treatises in their subject area. Some are called on to serve as expert witnesses in their field. Some have acted as prosecutors for the government. Some have worked as in-house counsel for some of the largest corporations in the world. So we are able to bring all of this wonderful experience, which usually you only find in big law firms. And because of our small size, we are able to offer personalized service to our clients. And of course, we also, I think, are a group of really nice people who believe in making a difference not only to our clients but also to to the greater legal community.
Awesome, incredible to hear. So business litigation can be very overwhelming for entrepreneurs. Can you talk about some of the most common disputes that business owners tend to face in the United States?
Sure. So of course, as you can imagine, I have seen my share of disputes over the years, but I would say the most common ones, I will say, fall under three big groups. The first is what I call breach of contract disputes, where there is a agreement between two parties to provide a product or a service, and one side either does not do what they're supposed to do, or do something or don't do what they're supposed to do, right? So we're talking about agreements such as supply agreements, purchase agreements, distribution agreements, vendor agreements, license agreements, where these are typically agreements between a business and a third party, where you have an agreement to deliver products at a particular time, at a particular price, and they fail to do that. So there is, either they have delivered the product late, or the product is not the right specification, and things like that. Mm-hmm. There is also agreements between and amongst the owners of the businesses, mm-hmm. such as shareholder agreements, partnership agreements, operating agreements. So any disputes dealing with arising out of those contracts also are, fall under this group. The second big group which leads to disputes is what I call fraud or wrongful acts. So here you don't necessarily have a contract, but the behavior or conduct of the parties is just wrong, and the law recognizes it to be wrong. Mm-hmm. So here you have claims of misrepresentation, where one side intentionally provides false information to make the other side do something. For example, you could be inflating financial records just so you can get a higher price when you're trying to sell your company. Or it could be embezzlement, where whether a director, owner, or even employee of the company takes company funds and is funneling it for personal use. Or you could also have a breach of fiduciary duty, where the director or owner of a company is putting his personal interest on top of the company interest. So for example, let's say you could be director in a real estate company, and in your capacity as director, you came to know of a wonderful, lucrative opportunity. Now, fiduciary duty obligates you to bring that opportunity to the company. Instead, you may decide to pursue it personally without company's knowledge. So that's a breach of fiduciary duty. So that's, again, all of these come under the fraud umbrella. Then the third one, which is common, is intellectual property disputes. So these are disputes relating to infringement of patents or infringement of trademarks and copyrights, misappropriation of trade secrets, or confidential information, domain disputes, and the like. So those, I would say, are the three big types of disputes.
Okay. Awesome. So when it comes to business agreements, what are the big mistakes that businesses usually make that lead to lawsuits?
Okay, so again, I think we could go at length discussing about this, but I will highlight maybe 4 or 5 that I see often in my practice. So the first is failing to actually document it, right? This means the parties have agree to do something, but they don't bother put it in writing. And this happens often in small businesses, especially where there are handshake agreements, because they believe, oh, I'm doing a deal with my best friend or my relative, or or it's too simple a deal. So they don't put it in writing, and often what happens is then it leads to, oh, he said, she said kind of lawsuits, which is very difficult to enforce. And then another mistake is failing to, not failing to, but having vague and ambiguous terms, right? Where you have a contract and it is in writing, however, the terms are not clear and they could be interpreted in more than one way. So, and often, of course, as you can imagine, one side will interpret and understand the term to mean one thing, and the other side will often understand it to mean the opposite or a different thing. So, for example, let's say you have a contract for a manufacturing facility, and the contract says the company should take reasonable steps to maintain sterility of the facility. Now, one side may think that involves sterilizing the equipment after end of each day, or whereas the other side may think it requires sterilizing it after every single batch. So where you have divergence of opinion. So it's not clear. The terms of the contract are not clear. The other way, the other mistake is failing to specify the roles and responsibilities properly. For example, you have a joint venture agreement, and it calls for both companies should promote the product together. Seems simple enough. However, when it comes down to the specifics, it's unclear, and it could cause disputes as to who is responsible for creating the marketing materials, who is responsible for creating the funding required for doing the marketing pitches, right? So that's unclear in terms of the roles. So that's often a mistake I see. And finally, I would say another mistake I see fairly often is actually failing to seek legal help before preparing contracts. Right? And again, I see this more with small businesses because they believe they understand the business well enough that they can draft their own contracts, or they believe, or they assume rather, that if you have gotten a template online, that is protecting you enough. But unfortunately, they don't come to lawyers until a dispute arises. So I would say those are probably, the fairly common mistakes I see.
Got it. So for those who might not be familiar, can you talk about the litigation process, and if they're what are the stages of that? How long does the process usually take?
Sure. So I guess, in the US at least, there are 2 separate, I would say, systems of courts. One is the state courts and one is the federal courts. And depending on the subject matter of your dispute, the amount at stake, where the companies are located, you might end up either in state court or in federal court. Most of my litigations are in federal court, so I will try to explain that as in that context. So for typically any federal litigation, you would have, I would say, 3 main stages. The first is the discovery stage, which is often the longest and the most contentious phase. This is where the complaint is filed, you respond to the complaint, you exchange documents, depositions, you file motions. All of this happens in the discovery stage. And once that is done, then you go on to the summary judgment stage. So here, both sides have gathered all their evidence, all their documents, all their witness examinations is done, and one or both sides believe that just based on the facts, because they believe facts are so clear or facts are so undisputed, that they should win even without going to a trial. Mm-hmm. So they will file for a summary judgment motion with the judge. Now, if the case doesn't get resolved at that stage, then it ends up going to trial, whether it's a bench trial before the judge or a trial before the jury, and this is what you often see on TV or in the news. So those are the ones. And I think in terms of like the length, right, it again varies based on what state you're in, what kind of litigation it is, which judge is it in front of. But a good ballpark would be probably 2 to 3 years. There could be, you might be in venues like Delaware or Texas, which are considered rocket docket cases and could go, maybe under 2 years. But it's normal to do 2 or 3 years or even longer in many cases.
Got it. So if a business owner is sued here in the United States, what are the steps that they can take to immediately protect themselves?
Yes. So I would say the first and foremost thing, please do not panic, right? Just to put it in context, businesses, and especially small businesses, get sued often. Almost 30 to 40% of small businesses are either sued or are faced with a threat of lawsuit every year. So it's not uncommon. So you have try to remain calm. Don't get emotional, and let's say call your other side and get into a fight with why they filed a lawsuit, or go about making public statements about the lawsuits, because they can come back to bite you. So that's one thing. The second, I would say, the businesses should do if you've gotten sued is preserve the evidence, right? That means don't destroy documents, don't delete emails, don't delete messages, don't tamper with evidence. Okay? You have an obligation once the litigation starts to preserve your evidence, whatever it is, whatever state it is. And then I would say hire a lawyer and get help. Because litigation is not something that you should be doing on your own. It's rarely a good idea to handle it on your own. So try to hire a lawyer that has the experience and someone that you trust. And you should also, once you're sued, you should also notify your insurance company. A lot of times insurance will cover for litigation expenses, so it's a good idea to check your insurance contract and notify them that a lawsuit has started. Finally, I would say, make sure litigation can be very disruptive, right? So it's a 2-3 year process, right, and it can impact your business operations. So try to have a plan of action to make sure that the business operations continue with minimal disruptions. Maybe you figure out who to delegate tasks to, address employee morale, things like that.
So from your experience, what are the most surprising or costly mistakes that business owners have made during the litigation process?
Yeah, that's a great question. And I have many examples of mistakes. I would say the big ones that come to mind, one is, and I'm talking about basic ones, right? One is ignoring the complaint. Believe it or not, a lot of times clients will, try to avoid getting served with the complaint papers, or pretend that you have not been served, or just ignore the complaint. Believe me, the complaint is not going away on its own. So it's never a good idea to ignore, responding to the complaint or addressing, the deadlines. It usually will result in a default judgment, which becomes much more costlier to undo and address. So that's one. The second one I would say is failing to or neglecting your discovery obligations, right? When a litigation starts, your adversary is entitled to look at all documents related to the dispute, whether you like it or not. Right? And that's something that a lot of clients don't appreciate or have a tough time coming to terms with. So they will try to do their best to delay producing the documents, delay doing depositions, which again leads to a lot of motion practice and increases the cost of the litigation. So that's another thing. The second or the third, I would say, would be to where you're not complying with your obligations, not just discovery obligations but other obligations, deadlines, meeting the deadlines, being available when the parties need you. So all of those ones are also mistakes that I've seen.
Got it. So my next question is, do cultural differences play a role in the litigation process or like make a difference in how the process unfolds?
Yes, definitely. I mean, I have over the years I've worked with different cultures. Definitely the Indian community. I've worked with European communities as well as other Asian communities, and every culture, believe it or not, has a different way of approaching the litigation, which impacts how the litigation proceeds. Talking about Indian community, I would say a couple of things that kind of are maybe somewhat unique to our community. One is their approach towards contracts, right? They they view contracts as simply a framework for negotiation, rather than the rigid document that it is. So what happens is when there is when one party doesn't keep their end of the bargain, the contract definitely gets breached, but the expectation is, we can just renegotiate the contract. We don't have to, enforce the breach. And so that's one approach. The other one I would say is a risk tolerance. Right? Risk tolerance is relatively low in our Indian community, and they don't want to pursue aggressive litigation tactics because either because they are worried about their reputation, because the litigations are all public, or they are concerned to preserve the relationships. They put a premium on preserving relationships, even if it means taking a financial hit. So I would say those two aspects, do kind of affect what happens.
Got it. So what are some proactive steps that business owners can take to minimize any legal risks when they are operating or expanding their businesses within the United States?
Sure, I think that's a great question. In fact, taking proactive steps is what distinguishes a successful business from a business that is not that successful. Right? So I'm big on being proactive. So I would say first thing would be make sure to have clear and comprehensive contracts. Right? It's not enough to have the agreement in writing. You have to make sure that it addresses all the details of all the situations. It accounts for alternative scenarios and what happens if things go wrong. So clear contracts, comprehensive contracts. The other thing they should do is comply with obligations. Right? First of all, figure out what regulations apply to your business. Whether it is tax regulations, immigration laws, employment laws, FDA-related regulations. So you have to identify what applies to your business and try to comply with those resolutions or regulations. And then you should also have a process in place to safeguard confidential information and data. You know, in today's day and age, there's a lot of breaches involving consumer data and confidential information. So it's a good idea to have a policy surrounding all this, you know, policy and procedures on, you know, how to store data, how to collect data, what uses the data can be made for, and, you know, all these other aspects that go with operating a business. So that's something they should definitely think about. And I would say, of course, finally, you know, do consider having legal help proactively before you enter into agreements. A lot of times, once the agreement is done and it's breached, it's too late to go back and fix it. At that time, you can only try to, you know, litigate it or try to, you know, settle it. But a lot of headaches can be avoided if we are proactive and in getting the expert help that is needed.
Awesome. So before we wrap up, I wanted to ask you if you have any additional pieces of advice or resources that you'd recommend to business owners to help protect their ventures.
Yes. So first of all, of course, you know, thank you for having me here. You know, as a lawyer, I always believe I put an emphasis on being informed, right? So business owners, if you're running a business and it's an active business, it's on you to keep yourself informed of what you need to know. So a couple of, I would say, you know, good resources for small businesses especially are, you know, the Small Business Association. You know, there's this website for Small Business Association, www.sba.com, which has a wealth of information about policies and guidelines for how to operate the business. And it has some helpful tips too. So that's a good website to start off. There's also the US Chambers.com website, which again, you know, gives good information about the basic guidelines and regulations that you need to keep track of. And there's always the local bar associations. A lot of them have small business legal clinics, and it's a good idea to, you know, attend one of those. If you have doubts, you can, you know, that's a good resource to keep in mind too. And in terms of just my advice, being a business lawyer and a litigator, you know, again, I say make legal planning your cornerstone for your business. You know, a lot of us will do estate planning, will planning, but, you know, I'm talking about a broader level legal planning for your business. You know, whether it is contracts, whether it is regulations, whether it is accounting for how disputes are resolved, whether it's conducting due diligence when you're trying to expand business. All of this, you need to have a plan in place and do it proactively. So I think that would save a lot of headaches, and of course try and find a lawyer, a business lawyer, to advise you that you can trust, right? A lot of times lawyers, including like myself, will take on clients where they don't have, small businesses often don't have in-house lawyers. So we will provide outside counsel services where they will say, you know, every month we'll give them, you know, a fixed amount of advice on, you know, hey, we'll review your contracts and we'll identify spot issues for you. So that kind of a thing is something that they should definitely keep in mind. Other than that, I really enjoyed our conversation. I hope the audience did too. And if you have any questions, please do not hesitate to reach out to me. More than happy to help. And I want to wish our audience a wonderful holiday season.
Thank you so much. This has been an incredible conversation. I know I learned a lot, and I'm sure the audience has as well. Thank you so much, everyone, for tuning in today with this conversation with Padmaja Chintha garu. We wish you the happiest holidays, and we'll see you next time.